application in connection with the first appeal. It will come, my lord.
First appeal.
First appeal. No, WST. Sorry, WST. I'm very sorry. my lord.
Application is for what?
For one restoration and
Give it. Any day. Any day.
Well, may I have your lordship kindly to mention, my
Very
lord,
sorry.
one matter. Your lordship was, my lord, kind enough to, my lord, pass this order on the last occasion regarding, my lord, that the problem with regard to, my lord, the disbursement of salary should be solved in a matter where, my lord, the petitioner was, my lord, directed, my lord, the transfer post to join and release. And now, my lord, the difficulty is this, lordship. After release, my lord, though there is no stay order, but, my lord, what happened? My lord, he has not joined neither in his transfer post nor in the earlier original post. Now, having not joined, well, let him, my lord, a direction, my lord, might be listed tomorrow.
Have you asked him to join at the earlier place? Have you asked him to join at the earlier place?
We have just a minute, bhai, please. We have not asked him to join.
Then
But, my lord, he is.
that is
not
what you are
joining.
supposed to
He is
resolve.
not- Lordship, kindly, my
That
lord.
is what you are supposed to resolve.
My lord, may I tell
If you
my lord,
can't do it, then we'll see.
my lord, without prejudice, lordship, kindly pass an order. We can
This
do
is
that.
not. This
Since
is
the
not
matter is
expected.
pending,
This is not
but-
expected.
But we pray before your lordship.
We have already passed an
My-
interim order. You had some difficulty. We have asked you to resolve.
My-
If you would have asked him that he should join his earlier post, why he will not join?
I do not know. He has not joined the post.
You ask him.
He has not
That look,
joined
for
the-
resolving this issue, for resolving this issue, you join your earlier post. He will join.
He
Why
has
he will not join?
Neither he joined in earlier post nor in the show.
We'll see. He's listening right now. What he does.
My lord, on last occasion, your lordship was eager to hear out the matter. My lord, my learned friend-
Because of that non-disbursement of salary, my lord was kind enough to pass this order last occasion.
upon his prayer. But your lordship was, Mr. Mojumdar
I
was-
am not.
He's mentioning. We are not hearing the matter. Please. Yes.
Now, my lord, we are ready to solve the problem. Lordship,
No,
kindly
it
consider.
appears you are not.
My lord,
Our prima facie opinion is you are not ready.
My lord, because of the finance department.
This is enough. If that is your problem, you could have asked him that he should join his earlier post for getting his salary. You think he will not join?
My lord, he has not.
For that, a direction is given to be given.
No, only without prejudice to the right.
What without prejudice? Where is the prejudice when it is in terms of an interim order? You are not only here as a mouthpiece of your client.
No, and I have been subject for long 14 years. I have not been paid anything. The matter was the e-statement of
What is it arising out of?
upgrading the list.
No upgradation right now. Take it back.
Lord, may I be permitted to mention one?
Appearing in the list.
So it will reckon up.
May I permit to mention the original side matter? Two matter, the matter to be
Original side. What is it?
it's a hearing, final hearing, my lord. The matter supposed to be listed on 28 November. The matter was directed by the Honorable Justice Division Bench, presided by my Lord Justice Sujoy Paul, Acting Chief Justice. May I permit to list it?
So if it is to be listed on 28th, then why you are mentioning today?
This is not the direction passed by the earlier bench. After determination, that's why, my lord, I am mentioning before your lordship.
Take it. If there is an order for listing, get it listed. If there is order, it should be listed.
The order has been, my lord, annexed.
Lord, may I be permitted to mention one matter? I have mentioned this matter.
Yes.
Lord, I have mentioned this matter on the last week. This is relates to the family pension to the second, to the minor son of the second wife, Lordship. The matter was yet to come on the 3rd of December last year. Lordship directs to mention this matter when the WPST will be taken up. So I'm mentioning this matter today. Lordship, kindly taken up the matter. The minor
Yes,
son is in
take it.
great difficulty.
Next coming Monday, on Monday.
On Monday. I'm grateful, Lordship, grateful.
Yes, hearing we are listing on Thursday. You include in the Thursday list. It will be included in Thursday list, but in chronological order, not at the top. What application? What is the application? You have filed an application in the, what application? In the appeal, you have filed any application? Can has been filed. Can is for what relief? It will be taken up. Yes. No. We are not going to give any. It is on the list already. All right. Inclusions. All you please give the. Don't mention the inclusion matters. Give the inclusions. Hearing matter. It will come on Thursday at the chronological order at its respective place.
Your Lordship, may I be permitted to mention, Your Lordship, item number 44 of today's list. We have mentioned the matter on the last Monday. Showing urgency of hearing of the application, Your Lordship was pleased to consider the same and direct us to inform the other side. It will be listed and taken up on Friday. Due to paucity of time, Your Lordship could not be able to taken up that matter, though it was listed. Today it is appearing at item number 44. Any day subject to Your Lordship, convenient, Your Lordship.
Let us see how it goes today and tomorrow. Yes.
One matter for inclusion placed with the
We said all inclusions, please give. All inclusions you give, it will come in the next month.
Lordship, may I have a kind leave to mention a urgent matter of the determination of Honorable Justice Jamil. This matter was mentioned on Friday. By the last order, the matter was the interim order was supposed to expire on the returnable date, which is today. And it was mentioned on Friday. Your Lordship, after hearing the urgency, had directed it to be listed today, but somehow it has not appeared in the list.
Why? We had allowed, why it has not come? What is this?
Lordship,
What is this? In spite of court's order. Call him. Yes.
Lordship, may I leave to mention, my lord, the reach application in WPST matter. My lord, 20th, my lord, order has been passed by the learned tribunal. 28th is days fixed for filing an application form fill up in the health department. My lord, the reach application order has not been uploaded as yet.
What has not been uploaded?
My lord, order which has been passed, my lord, 28th 11, that has not been uploaded as yet.
28th 11.
28th 11. That is, my lord, the 20th November. That just my last week.
28th is
20
November.
20.
So what do you want?
My lord, the 28th, my lord, date is fixed for before the filing an application. And the learned tribunal fixed the date on my lord, June 2025. My lord, unless my lord, this WPST has been heard, my lord, my client has not my lord, make an application for
So on 2011, which court has passed the order?
20th 11 learned tribunal. WPST matter, my lord, state tribunal matter.
28th, now it cannot be taken up.
24th, today we are on 24th. My lord, the 48 hours, my lord, appellate side rules, my lord, covers. My lord, if your lordship grant leave, otherwise, my lord, is the last
What
day.
is 48 hours?
My lord, the appellate side rules is 48 hours we have to serve notice.
Yes.
Otherwise, we cannot get.
You serve a notice.
Serve notice, my lord. Well, unless, my lord, the writ has been filed, otherwise.
So there is no order and you want to file a writ
uh,
petition. How
That
it
is, my
can,
lord, the difficulty.
how it can be? Sorry. You see, will be available tomorrow. You try to get the order. Yes.
A online copy, value, you also can't leave to online copy, then I will.
Just now you said order has not been
Order was-
uploaded. Now you are saying online.
When in the evening.
Be sure of what you are mentioning.
No, no, in
Don't
the
mention
evening-
on if and buts. Yes.
The evening, well, I get it, my lord.
We don't know. Yes. This is not the way to mention. Yes. But there is no service. There is an affidavit of service, but there is no order recording that service has been effected. That we have seen. Yes. Please, this is not the way. Yes. You cannot every day come and mention that in that case I have missed something, you list it again. This is not the way. We allowed you so much time, you argued at length. Yes. Huh? Yes. Group 6. Group 6 is this is Jamil. Yes, what do you want? Yes, we are saying all inclusions, please give. It will come in the list.
My lord, today my matter is listed at item number 28 under group 6. My lord, I have traveled from Varanasi to appear in this matter as in person. Kindly, my lord, I humbly request to take my matter early, my lord.
We'll see. You wait. Yes. You wait. Yes.
Worship, can the matter appear at 2 p.m. today? Supplementary list.
You give the number. We are looking into it. Why it has not
Clear
come.
list.
Group 6 hearing matter, my lord.
Who has not sent? Yes.
Item number 1,
Correct, sir.
But may I just indicate, my lord, in item number 1, my lord, the year has gone wrong.
What has gone wrong?
Year.
Of the case.
The cost title has also been wrong. Corresponding to that year.
It's what is the correct number?
19, it is 2014. Cost list, it is 2014.
I am unable to understand.
Cost list, the number has gone down as of 2014, my lord, 166 of 2014, where the original would be 2019.
So what do you want? You want correction of the no order is required. It's wrongly listed.
This matter is listed for orders, my lord. But this, in the cost list, the number has gone down.
So today it is not listed, that means 166 is wrongly listed. Yes, no order.
Letter may be appeared.
It will come. There is an order for listing today.
Yes, yes.
So list it tomorrow.
item number 2, 3, item number 3,
Well, item number 3, my lord, I appeal for the petitioner. Lord. This matter also relates to resignation of a doctor, my lord. Issues has been settled by your lordship. That was there in the original application. The learned tribunal directed authorities to consider.
When are those matters?
My lord, on 1st of December.
Let it come on that day.
Let this be also on that day, my lord.
Yes.
Not active with the tribunal, sir.
The other matters. Okay. 112. No. Who is it? ठीक है
Item number 4.
I'm for the petitioner, my lord. We're praying for short pass over my lord. My lord, kindly, my lord, my lord, and for Pompa, the whole my lord appearing on the petitioner, my lord, we are saying court number 2, my lord. The matter is going on, my lord.
after this assigned matter 2 p.m. Therefore, I am saying there is one matter assigned, another this will be at 2 p.m. Yes, what is the issue?
Compassionate appointment.
Compassionate appointment. Yes, who is for the respondent? File a opposition. Yes. Let opposition be.
Vice Baru. Item number 5.
My lord, I beg to appear on behalf of the applicant. The affidavit of service may be kept.
I am for the respondents.
This affidavit of service taken on record.
My lord, the appellant, put your lordship, my lord, they have participated in a selection process conducted by the staff selection. The my lord, it is for the post of general
Conducted by Staff Selection Commission.
commission.
State.
Yes, no. Central.
Central.
This is for the appointment of general duty constables at various, my lord.
Constable GD in which organization?
This is for Assam Rifles. Now, my lord,
Paramilitary.
yes. Now, my lord, what has happened is there is a computer-based test. They have qualified, and subsequent to that, my lord, what happened is the appellant was rejected on the ground that he didn't achieve the height that was required. Now, my lord,
What was the height requirement?
170 centimeter is the
170.
170 centimeter is the height.
And they say you are short by?
I am short by 0.03. Now, my lord, in my respectful submission, my lord, that comes from a benefit that has accrued in my favor in terms of the rules frame, that there is a scope of rounding off. Now, my lord, if I am 169.5 and 169.9, then, my lord, the scope of rounding off comes in my favor and I will be considered as 170 centimeters.
Yes.
Now, my lord, the writ petition was moved on this ground. The Honorable, my lord, single judge held that since there is an appeal provision, I will have to approach the appellate authority. Now, my lord, in my respectful submission, my lord, if a benefit has been given to me, that has to be, my lord, given to me at the very first available opportunity. Now, my lord, since I have already, my lord, held that I have crossed 169.5, the scope of rounding off comes in my favor. Now, my
So
lord,
therefore, you should not be required to go before the appellate authority.
yes, this is my respectful submission.
Why? Under which provision, under which law, if there is an appeal provided, you should not avail the review appeal, and the writ court should exercise jurisdiction
Yes, because
just like that.
in my respectful submission, if a lordship considers that there has been a benefit that has been given.
There is an illegality.
Yes.
Now every appeal will be filed if there is an illegality. You will not file an appeal if everything is all right.
My lord, in a departmental appeal, I am not agreed by my
Where is
side.
the appeal provision? Let us see.
Yes, my lord, I will hand over.
And where is the rounding off provision? Both.
Well, I will take your lordship, my lord, one after the other. Since it has fallen from your lordship of the appeal provisions, I am handing over, and my lord, I will also handing over the rounding of provisions. My lord, should I hand over the rounding of provision first?
No, let us see. Where is the appeal provision?
Candidates who are declared not qualified in physical standards, height and chest have qualified. There is no dispute about that. May prefer an appeal on the same date if they so desire to the appellate authority nominated for the center through the presiding officer. The decision of the appellate authority will be final and no further appeal or representation in this regard will be entertained thereafter. There is no appeal in paid. That is, my lord, the res. So, my lord, this is the appeal provision. If I so desire, I may prefer an appeal.
And if you don't desire, then
Because, my lord, in my respectful submission, I have already qualified.
We are saying if you don't desire an appeal, then what is the inference or what is the natural corollary from reading of the provision?
That means, my lord, the inference will come that I am not being aggrieved by the height itself, but I am aggrieved by the, my lord, way that benefit was not granted to me.
We don't know how such a submission is being made.
My lord, may I then take your lordship only to the rounding of
The no, we are not going to enter into that, sir.
my lord.
There is a provision. If you desire, if you are aggrieved, you have to avail review. If you are not aggrieved, you don't do anything. Why writ court? Either you are aggrieved and you desire to avail the remedy, or you are not aggrieved and you don't desire to avail the remedy. Please, the Honorable Single Judge has been kind enough to grant you further 3 days time from the date. Still, you are not availing the remedy.
Yes, because, my lord, the question that is, my lord, this is just going on, my lord. If I may, lordship will kindly not take me amiss.
Yes.
The fact remains is, my lord, if a benefit is there, at
That's
which
not the
stage-
point. The point is an illegality.
At which stage-
According to you, and you have been made to suffer an illegality. There is a
Absolutely,
benefit
madam.
which has not been extended to you.
Absolutely, yeah.
Now, for that, a provision is prescribing a remedy. You are not desirous of availing the remedy,
At what
which we
stage-
can conclude now, because even after the single judge, you are not desirous of availing the remedy.
Because, my lord, that will be, my lord, in my respectful submission. My lord, I'm extremely sorry, my lord, if I may submit in this way, because the question that was going on in our mind is at what stage that benefit will accrue in my favor, which has been granted in the
We
rule.
are not going to go into that. The primary thing is the rule says for such a situation, you have a remedy, and the rule says only if you desire to avail the remedy, you may do it on the same day. Obviously, you did not desire. When did you file the writ petition?
My lord, the
After how many days of the measurement?
may I-
What was the day of physical measurement? Such a person is to be employed in a disciplinary force.
August 20.
Please, yes, let him speak.
my lord, just a minute.
If before employment this is how you are behaving, then after getting into a paramilitary force, what you will do is another issue which arises.
My lord, it's in annexure, page 39,
Give us the date, please.
28th August 25.
Was the measurement
Yes.
and writ filed on?
Then, my lord, there is one incident that I must indicate that I couldn't prefer. There was this thing, my lord, and representation made on the subsequent date, that is on subsequent date, that is on October 4, that I highlighted.
4th October.
Yes.
After so many days.
Yes, my lord.
After more than 1 month.
Yes, my lord.
About 1.5 months later.
And the, my lord, writ petition is filed on 29th October.
So now we understand why you are harping on the writ courts. Why did you not file? That means you are not desirous. That's the only logical conclusion possible. Maybe we would have understood you for some reason could not make it the same day as per the rule. You would have gone the next day saying that look, for this and this reason I could not do it. Where is your representation of 4/10/25?
My lord, from page 40 onwards.
40.
Yes.
No, that's not your representation. 40 is the order of the court. And where have you stated about the representation in your writ petition?
My lord, may I? করে দিতাম আচ্ছা রিট পিটিশনটা চাইছি Well, that is in paragraph that is annexure P4 in my writ application.
We are unable to locate, therefore we are asking, can you please give us the page number? It is not 40.
Page number.
On 9th October 25, you filed. Not 4th. It is of 9th. And it is an email.
That was an email sent.
What was the filing?
এটা পিটিশনটা আলাদা হয়ে গেছে।
Where is your assertion regarding filing of the writ appeal, regarding filing of the appeal before the authority in your writ petition?
My lord, only
There is no appeal.
there was only an the appeal has to be preferred on the same date. The rule
Where is your assertion?
there is nothing because that was done on a subsequent date. I cannot, my lord, improve on that.
No, but therefore, what have you said? Why on 9th August? That is what we are trying to assert.
I'm coming to that.
That we have understood that it's not an appeal.
P4 আপনি
So was it an annexure in the writ court? Or it is?
my lord, I find that it has not been, it has been there, but the fact remains is, my lord, there is no pleading to that effect.
No, there is no annexure also. In the writ.
এটা কোন ম্যাটারটা একটু বলুন না, দুটো ম্যাটার দিয়ে যাচ্ছে আপনি ছেড়ে দিন, আমি দেখে দিন এটাতে কোনো অ্যানেক্সচার নেই। সুমিত 9th October email has been annexed, but there has been no pleading to that effect, my lord.
It's not part of the writ petition.
Yes, I cannot place
It is
that.
maybe you have an exit, they have an exit here, but it was
I cannot
not part of
rely
the
on
writ.
that. And if there was a pleading, I could have relied on. I'm not relying on that.
No, there's no pleading and there's no annexure also.
Yes,
Please
yes,
see in
yes.
the index also, it is not
Yes,
mentioned.
it's not there. I cannot. I should not, my lord, also proceed on that. Only since your lordship has been deciding on this issue, my lord,
For such a person wanting to get into a paramilitary force, we don't think the red court has been too kind to you.
yes, my lord, I tell your lordship what has
Kind
happened.
to you.
What has happened, I'll tell your lordship, my lord.
We don't know why they have also perhaps been kind to go with the order.
Yes, my lord. There have been several orders wherein, my lord, we have, my lord, done so because there has been pleading to that effect that on the very same date, the situation so warranted that they couldn't prefer an appeal. There was pleading in many.
That's why we asked you, from our experience also, we asked you that what have you said, under what circumstance?
My lord, I bow down to your lordship, my lord, there is no pleading to that effect.
For such a person.
Yes, my lord, that person, my lord, the desirous persons, my lord, your lordship was kind enough only to, my lord, extend the time.
No, sir. Had it been any other service, we could have understood. Central paramilitary force, such a person. He does not file appeal. After months, he approaches the writ court. He is supposed to file appeal on the same day.
Same date.
After months, he approaches the writ
Yes.
court. Writ court is kind enough to grant him 3 days. Now he's in appeal. What kind of service he will render a paramilitary force? We are slightly skeptical about it.
Lordship knows, my lord, what has probably prevailed in his mind is that there is a scope of rounding off, and that rounding off was.
Who says no? Who has said no? That's the
Absolutely.
point.
So, my lord, if the
He is not desirous. He is not desirous. At least to say about his discipline.
Only
He's
since
not
your lordship
desirous.
has already, my lord, deciding on this issue, my lord, may I make only
We don't
one,
know
one
because
respectful submission?
after this 3 day was granted to you, maybe 2-3 weeks back, whenever it was. What is the date of the order? 10th November.
Yes.
We
So,
don't
my
know.
lord, only one thing, if I may so submit. What probably could have prevailed in his mind is that since he has already crossed the hurdle of 169.5, he has, my lord, come within this consideration zone. So, my lord, the appeal he need not prefer. That probably could have, my lord, played in his mind.
He has understood the rule quite well.
My lord,
He is asserting that he needs to be rounded off.
yes.
It's not that he doesn't understand. And if he doesn't understand, then he doesn't understand. Can that be a plea?
Lordship, this is misleading because that be rounded.
Please, we'll come to you if required. Yes.
My lord, apart from that, my lord, I cannot say. Only, my lord, respectfully submit that if your lordship considers kindly, my lord,
See, again we are saying, any other service, such a plea of leniency could have been appreciated. For a central paramilitary force, we don't think he should be given any further leniency. It's too much.
my lord, I will not proceed any further.
Should not be encouraged. His lordship is also correct.
My lord, I will not proceed any further, my lord.
Yes,
Whatever falls from your lordship, my lord, I will
heard the learned advocate.
Leading his submission.
Please tell us tomorrow.
No, already,
I am
already,
says so, my
no,
lord.
there's a
We are
rule
not-
come at time of the final section, that is DME, detailed medical examination, but not at the first stage. It gets already first stage rejected.
Then-
There's no question of the wrong way.
No, my lord, in that case,
Because this is our
it
rule.
is a very hurtful statement that came that I was misleading your lordship.
No, definitely not.
Kindly, my lord, take up the rules for once.
He has rejected at the PhD, physical test, first time, rejected. After that, there's BMI, the body mass index. In that way, he found that it will be rounded up, not at the first stage.
Well,
If the first is rejected, how I can proceed with them?
What is PST?
Physical standard test.
Now, what is the rule?
Sir, no,
My lord, may I hand over? My lord, the rule is here.
Oh, you have given us the rule.
My lord, I have given the rules for making appeal.
this is
The
particular
rounding,
guideline.
this is rounding of rules is here, my lord.
We are not on rounding off. We are on, he's saying that appeal could not be filed at this stage.
No. When at the BMI, already you have done PSC, then one of within that day they can file the appeal. They have not chosen that.
How can you argue that you have the honorable single judge has considered everything, passed an order, you have not filed any appeal? How can you argue make such an
I'm
argument?
not arguing. Lordship has given if there is any provision for the appeal, he has.
Where he has said if any provision, please,
There is no provision.
where the honorable single judge has said that if there is any provision for appeal,
There is no provision.
then why are you saying that?
Lordship, there are 300 petitions filed. Similar.
See, you are making submission after submission.
No.
Your only objection is that this was not the stage at which he could file the appeal. How you can argue this when you have not said anything before the honorable single judge? The honorable single judge has proceeded as if he had an opportunity for filing an appeal. How you can argue like this?
I was not at that time.
So therefore, it is open to you to argue whatever you want. Then
I'm sorry for that.
you have not filed an appeal. How can you make such an argument? You are turning the table on the order, trying to turn the table on what the conclusions have been arrived at. There is no appeal. You have there is no argument also. How you can make such an argument?
Submitted before Lordship. But even then there was some
Please don't make such arguments.
Lordship, sometimes we are kind enough that okay, if the appeal provision is there, you go extension.
We are not on sometimes, we are on this case. Where does it say that if appeal provision is there?
I'm not.
You are trying to read something in the order which is not there,
Lordship, in another manner.
arguing everything in air.
Lordship, if the Lordship is asking, can he appeal? I can extend the time. So that's why Lordship has allowed. There is no provision. Even then, if the Lordship
You
is allowed-
cannot make this argument. You cannot make this argument. You have not challenged the order. The order records that there is a provision of appeal. Where does it say that if there is a provision? Please read from the single judge order. What kind of argument you are advancing? He says there is a provision, we are granting him 3 more days. And today you are arguing that there is no provision. You are not challenging the order and you are arguing something contrary. As if it is your appeal. Submit anything without going through the order also. Very unfortunate.
Rules, my lord, these are taken out during every recruitment process. And there is an uniform guideline for, my lord, what I have submitted is of rounding off, which your lordships has, my lord, said that
No,
your
the honorable
lordship-
single judge has accepted everything.
Absolutely.
He has given you 3 days.
My conduct is now under, my lord.
Yes, your conduct is under serious scrutiny.
Absolutely. My lord,
Such
I
person in our view.
beyond that. My lord, that there is a provision of rounding off, there is a provision of appeal, and I didn't avail the remedy. If your lordship kindly considers that part, nothing else. Maybe I can come up with a better case some other day, but today.
Why even after the single judge order you did not avail?
Absolutely, my lord, that ought to have been, my lord, that advice should have come from us. I tell your lordship, my lord. That advice should have come. from
Created
us.
problem created for yourself.
Yes.
The moment we open such a floodgate, just imagine what will happen to the recruitment process.
Absolutely. And beyond the dates also, my lord, it will be. So, my lord, if your lordship only, my lord, grants me a last opportunity,
We don't know. That's why we said, what is the position today?
if the position permits, they will grant me, and if the position doesn't permit, they will not grant me. Only that 3 days, let it remain 3 days, but from today, my lord, kindly grants me a 3 days liberty. Nothing
No,
else.
we don't want to pass an order in uncertainty. You please find out if it is closed or not. Tell us tomorrow. If it is closed, then
I have to come to Delhi.
just find out on
No,
take
sir, I
telephone.
will find out.
Yes.
Lordship,
Prima facie, we are not.
exhaust the matter for the next.
No. Because see, if it is closed, then it is closed. Therefore, we are saying if it is not closed, we may see what we have.
Find out.
My lord, the
The same-
next matter is
same,
same.
sir.
I am handing over the affidavit.
Next matter is the same.
Same matter.
100, return you 200, analogous. Same.
No, no, no.
So 1.179.5, 6, this is.
To affidavit of substance. Only, my lord, one.
If you actually prefer, then it will reflect all over India the same service job also.
Anyway, we'll see.
My lord, I have not misleaded your lordship, my lord. This statement was very hurtful from a senior friend like this.
No,
I will not do that.
We don't want to say anything.
No, my lord. These kinds of statements from a senior members,
No, no.
from other members.
Why? So the rules is there. Then why I cannot
Hide
go
the
beyond the
rules.
rules.
Hate this order. Don't put aspersions on me.
So misleading. You
Say.
plan. You
Say.
plan and mislead.
I am
You plan.
misleading.
Lawyer cannot be mislead to anybody.
That is a mixed statement you are making.
Same order in both the cases.
Item number 7.
7, 9.
It is not closed. He has to go. He doesn't.
Seven, Petitioner. This is a matter that is compulsory appointment on special scheme 2020. Weight of the
Supplementary affidavit.
my lord. This is the supplementary.
No copy has been served upon us.
I'm giving copy.
A supplementary affidavit is
Item number 8.
On 8, I'm for petition of my lord. On last occasion, your lordships can't be leave to translate the copies, my lord. But it has not been properly done, my lord, because there is some, well, I am seeking some more time. Because
the learned advocate for
ট্রান্সলেশন করতে পারি না একটু।
Item number 9.
Your lordship. But after the petitioner, not in this matter. But this matter, am I, my lord, audible to your lordship's matter?
loud and clear, yes.
Yes. So I just tell your lordship, my lord, this matter, my lord, pertains to, my lord, the regularization of the petitioners, which, my lord, they prayed initially, and there was
The arguing counsel, Mr. Amritulal Chatterjee of this matter is engaged in courtroom number 30, your lordship. Short passover can be done, your lordship. Affidavit on earlier occasion filed and it's for exchange also.
So no exchange is required.
No, nothing was remaining.
Just give us a moment. So let him start, he will come. Yes.
But there may be a difficulty, my lord, that I may face during the hearing. Not they mistakenly, my lord, my learned friend, my lord, has just given me the original copy of the affidavit in reply in my brief, which is right now, my lord, lying with me. So, my lord, that though, my lord, I will not be relying upon the affidavit in reply at all.
Not today, not today.
As your lordship, please.
Let's see.
Item number 10.
None appears. None appears on behalf.
Item number 11.
Well, I'll get your lordship, please to direct my.
Yes, your lordship. There was a direction to produce their application. And your lordship, there was a query regarding the definition of family in the regulation. Lordship, this is the application, your lordship. Your lordship, in the application,
What was the misleading statement?
your lordship, the misleading statement was made in the affidavit where they had specifically submitted that the brother had been living separately, though earning, had no connection with them and had been living separately. But on inquiry, it was found that they were living as a family altogether, and the annual income that had been shown was absolutely wrong. Your lordship, there is a specific statement made in our opposition where it has been indicated that they had, though despite being an monthly income of 80,000, they had declared their monthly income to be 24,000 only. Your lordship, kindly see page 11, paragraph 11, subpara F. This false statement is at page 16 of the opposition.
So how many offspring the deceased had? Two brothers and one sister.
Two brothers and one sister, which
The sister is living in her matrimonial home.
is your lordship, married.
And these two, according to you in the inquiry, has come out that they are living together
They are living together.
in the ancestral house.
In the ancestral house, they are living together. The salary slip of the brother has also been annexed at page 28 of the opposition.
So there are two aspects. One is whether they are living together or not. The other is, can the siblings' income be clubbed with this?
Family, as defined in the regulation, that is 251 MP, includes spouse, son, unmarried daughter. Your lordship. So all the sons would be included in the family, your lordship.
That is, of course, one son, if he is included, other has to be. That's not the point. The point is,
and when
the person who is claiming, the benefit, can he be excluded because his brother is employed somewhere?
Regulation, eligibility criteria.
And his brother is in government service.
It is my lord school.
School. He's
He said that the
he is in the Bodhra Pantheshwar High School. Your Lordship, government sponsored school. Your Lordship, the eligibility criteria is that the family as a whole, the family is indigent and deserves immediate assistance from financial destitute. For this, Your Lordship, the monthly income of the family has to fall below 90% of the gross monthly salary.
This is in 251.
Yes, Your Lordship. Clause
well,
6,
I
Your
am showing the that is eligibility.
Your Lordship, 6A. The eligibility is on the basis of family income.
The monthly income, that is
Monthly
well as
family income, Your Lordship.
one. Your Lordship.
You want us to understand anything, or you just want that
Oh,
both
no,
of you should
Your
keep
Lordship,
speaking? Yes. Six.
6A, Your Lordship.
Huh. And when the three-member committee considers this aspect, what is the format on which available information is available to the committee?
Your Lordship, the declarations are given by the applicant.
On which format?
Your Lordship, the format which has been submitted to Your Lordship.
Just now, which you have given?
Yes, Your Lordship.
The one you have given us just now.
Yes, Your Lordship. This is the format in which the application is.
So does this require disclosure of brother's income also?
This is a declaration where there are more than 2 siblings, Your Lordship. The affidavits are to be submitted by the others, Your Lordship. The affidavit submitted by the brother is at page.
No, this is the form which is being considered by the.
This is the form. Thereafter, an affidavit is submitted for no objection of the brother. Affidavit from no objection.
No, this is to take care of it.
Where is the affidavit submitted? The affidavit is on record.
Yes, Your Lordship. Page 15 of the
Yes,
opposition.
16.
15, Your Lordship. Starting from 15. The relevant portion is at page 16.
Yes.
Your Lordship, 6A clearly says that the monthly income of the family, Your Lordship. This is an appointment in Group D, Your Lordship. If the group,
Is there any requirement of disclosing the income of the sibling?
Your Lordship, it comes as a family, Your Lordship, the family income. It is not an individual income. Your Lordship, the family indigent and deserves immediate assistance, Your
But
Lordship.
our question was whether his income can be taken into.
Yes, Your Lordship, the family as defined in clause 3 includes the spouse, son, unmarried daughter, Your Lordship.
That you have
And they are
already
living
submitted.
together, Your Lordship.
That you had submitted on the last day.
Yes, Your
Still, we asked you
Yes, Your Lordship.
whether his income can be taken into consideration or
That
not.
has to be taken into consideration for the family income.
That is family for the purpose of benefit of the scheme. We are asking you whether while granting such benefit, the siblings' income is to be considered.
It comes with
Unless it is required, why, even if he doesn't disclose or he discloses, what difference it will make?
Your Lordship, it comes within the family, definition of a family.
That's
So
not
family
the issue.
income has to include whoever.
No, family income, that is definition of family.
Yes, Your Lordship.
That's not definition of family income.
So the
So
family,
precisely, from where do you get this? That
family, if the family, Your Lordship, subject to correction by Your Lordship, if the family includes the wife and the sons, Your Lordship, and they are staying
therefore,
together.
by inference, all their income is required to be taken into consideration.
Lordship, the regulation eligibility criteria includes that the entire family income has to be
So
considered.
family income, therefore, where is family income defined? That each and every member's income has to be clubbed together to.
Lordship,
Because you see, it says pension, the amount received from pension, amount received from gratuity, and all these things are there. It does not say amount received as salary by the sibling, does it anywhere?
Your Lordship, the family, Your Lordship, may I read this? The monthly income of the family falls within 90% of the gross monthly salary of the employee, Your Lordship.
So therefore, see part 2 of the form. These are the only incomes which are required to be considered. Family pension, death gratuity, GPF, group insurance, leave encashment. You don't ask for anything else.
Your Lordship, these are the income, these are the disbursement that has been made by the authorities upon the demise of the employee, Your Lordship.
You have not looked hard enough.
If the definition family, Your Lordship, subject to kind consideration, if the family.
Please see clause 3 of part 2.
Yes.
Your answer is there, but you are not finding it.
It is also specifically stated, my lord, 6(1).
Particulars of all dependents of the deceased is required to be disclosed.
Any other assets, Your Lordship? Pension, family, part 2, Your Lordship.
No. Clause 3 at part 2.
Clause 3.
Particulars of all dependents of the deceased.
Your Lordship.
Where he was required to give the
Brother,
third
Your
person in the third column has been left blank. And you see clause 8 of that table. It requires particulars of occupation, employment, if already employed, and clause 9 is the salary. So salary of the sibling was required to be disclosed.
Yes, your lordship, and thereafter also.
This you are not pointing out.
I'm extremely sorry, your lordship. It skipped my. Grateful, your lordship. Particularly, your lordship.
One your lordship kindness. This is the circular monthly family pension. The monthly family pension shall mean aggregate of total family per person pensions per month and whether they include the fluctuations.
What are you showing?
Yes, the circular.
Which circular?
That is whether the West Bengal Service Scheme of the Compensation Appointment 2005.
251. Ah, we have seen that. We have it.
It's not we kindly hand to us.
We have it. Why are you worried? We have it. We are looking at it. Clause 6.
I want to see. And it is circular.
6A is there. Family is indigent.
Monthly. Yes. One, well, that is total family pension per month. That means calculation has to be submitted on the
Suppression of material because see there are 9 columns. One is the name, the age, education, relationship, so wife, son, whether living separately or not, whether that sibling is married or not, whether he has to keep the name of the whether he's employed or not. He's employed. Yes.
income of the sibling minor is has been excluded total.
You have given him a copy of this. Give him a copy. That is your application, sir. You please see part 2, clause 3. Clause 3 required you to disclose the name of your brother. In clause 6 of clause 3, you were required to say that he was living separately. In clause 7, you were required to disclose his marital status. In clause 8, you were required to disclose whether he is employed or not. In clause 9, you were required to disclose his salary. Why you have not disclosed anything about it?
Your lordship can give me only 1 day time. 1 day time.
Copy of the pro forma application.
You stay, Mr. Wigmailer, I will not be there. You lost Thursday. Thursday.
Next Monday. No, after that.
Thursday. Well, you lost I will be for the last
15.
15th December.
See, that is why we asked you to bring on record the pro forma. Because whatever is required to be disclosed and considered, it will be there itself. Yes.
There is one attribute, I am coming. Attested copy is there. I am coming.
Item number 12.
Your Lordship, I for the petitioner. The last occasion is 6-1 accommodation for filing the opposition. We have been not yet been served, Your Lordship.
I am PSC. My ma'am is Miss Shravani Sarkar. Shravani Sarkar is engaged in court number 1. Kindly give short person.
Where is the opposition? Give her a copy. Opposition, affidavit in opposition. No, not 9th. No, not 9th. 2nd. Why 9th? 2nd. Yes, 2nd. And that in that one also, why you have given 15th? It should have been 8th. You are skipping 1 week.
I shall not be available, Your Lordship, 2nd December. We keep it on the 2nd week of December, Your Lordship.
All right, 8th. 8th. Yes.
তাহলে 11টাও 8
সেটা হলো 8 তারিখ আর আগেরটা হলো 8 তারিখ
আগেরটা
ওই 8 তারিখ
না এটা নয় এটা তো নয়
থাকবে না
কত তারিখ বলুন
8 তারিখ
8 বলুন
8.
দুটোই 8 তাহলে
হুম.
Item number 13.
Which is my appeal. The last occasion directed me to serve GP office. I will be served. It's my affidavit.
All respondents.
My respondents,
How many respondents are there?
7 respondent.
How many official respondents? All official. 1 to 4. And who are 5, 6, and 7?
5, the SPIO Motor Vehicle Department, Chinsura, Hubli, and 6 the private respondent, and the 7 is the branch manager, Allahabad Bank.
So 5 will be represented by you only. 6 and 7 have been served.
I will evident service in the
So nobody is appearing for the bank also. Is someone appearing for the bank?
Your Lordship, given indulgence to service another notice upon the bank.
Let us see what is the issue.
But 75 days delay
In
in appeal. 75 days delay. The section 5 application file. The only grounds is that the first time when my client obtained the certified copy that has been damaged by the rain. On the basis of that, second application has been made, and after receiving
so serve on the other respondents. let notice of the application be
Item number 14.
Last occasion I submitted that I do not intend to withdraw this writ petition, my lord. I have received the instruction. The petitioners are also physically present before the court.
I'm approved for the election.
I'm sorry. It's item now. My item number 15.
15. Attorney, madam.
My lord,
Item number 14.
item number 14, my lord. I'm praying for an accommodation, my lord, on behalf of Mr. Robiul Islam, my lord. Due to personal difficulty, he could not come to court, my lord. We'll argue tomorrow, my lord.
not today?
My lord.
Yes.
Fifteen.
Private respond.
There are two signatures. There are two writ petitioners,
Yes, the writ petition was affirmed by only Shushila Lakra.
but there are actually two writ petitioners.
To the father and the mother. This is the matter is related to pensionary benefit of the deceased son of the petitioners. So what happened, my lord, in this proceeding, my lord, there are some dispute regarding the status of the wife, my lord. So perhaps, my lord, I have to go to a civil court to seek my.
So you need liberty.
I need liberty, my lord.
Yes.
Much obliged. Much obliged.
The
Point was considered.
huh?
This point was considered. My lord, they are disputing my status.
He wants to withdraw. He learned an advocate for the writ petitioner.
No, it is in my favor.
Then
Item number 16.
16, my lord, I appeal for the petitioner.
16, Lordship, I appear. I'm led by Mr. Thomas in the double H. And he's prayed for some time, Lordship.
Only thing, my lord,
Petitioner.
only thing, my lord, your lordship may recall, my lord, this matter relates to second inquiry. My lord, this is my purported contention before your lordship that I am being proceeded with. My lord, the inquiring authority by an order dated.
he is in difficulty then.
See, my only thing, a piece of paper was handed over on the last occasion to your lordship, my lord, but Although my learned senior friend assured me to supply it, he has sent it to mail, my lord, I couldn't find it. It might have jumped back.
Why don't you give him a copy, whatever you are relying?
Getting to know right now. He's never got back to us.
What
so
is
I
that
will ensure
document?
that it,
Lord,
remains another
Some
copy.
list of dates have been placed with your lordship, my lord. Your lordship directed him to take instruction with regard to what is the delay or something, my lord. He has placed something, he has assured me to it.
List of dates.
But if your lordship of hand over.
Sure, thank you, my lord. But only thing, my lord,
Not today. Let's see tomorrow. Tomorrow is not a problem.
no, my lord, tomorrow is not an issue, my lord. Only thing, my lord, when the first matter was heard, your lordship granted me some protection which was valid till 21st or 21st of this month. My lord, again,
Tomorrow we are taking.
Item number 17.
I'm not very well today, Mirror. I am not very well today. I'm indisposed. I have come because on my request, Mirror, this matter has been fixed up. Suffering. If your lordship, Mirror, kindly.
When? After a week?
After a week, Mirror.
As prayed.
This with regard to the vigilance, Milord, only one page note. Your lordships were asked.
Oh,
I could not reach court, Milord, on that day, Milord. Because your lordship's query was from the additional advocate general that whether it is an act of legislature. According to my Milord, it is an act of resolution, 4th March 1965, Milord, taken by the legislature. Government.
so in clause 3, it enables them to investigate the departmental issues also.
Even then, Milord, your lordships have asked Mr. Mukherjee, Lane's senior advocate, Milord, to provide the manual also.
Provide the
manual. The manual.
Yes.
This manual was subsequently, Milord, adopted by this was a manual, Milord, with regard to, Milord, the West Bengal Power Development Corporation.
Power Development
Corporation. Milord, this is extensive power. Extensive power, but not an act of legislature and not is a sequel to, Milord, a decision under Article 309 of the Constitution also.
There is no rule.
It is not a decision also. It is only a resolution. But
an administrative instruction only.
Instruction only.
In the nature of an administrative instruction.
But Milord, for the sake of smooth running of the administration, Milord, it was required apart from Milord.
No, then another issue which arises is an inquiry is being conducted under a rule framed under the proviso to 309. So how this person is looking into the investigation?
No, because I think, Milord, since your lordship's query was from the additional advocate general to provide the manual also, whether any subsequent decision had been taken by but it is they said, Milord, the government can, Milord, only for this reason, but it is not a conclusive one, Milord. It is subject to further inquiry and the charge sheet.
1, 2, and 4 are, of course, there is no doubt. But regarding 3, whether they can overlap with the CCS or not.
Milord. Since, Milord, at one point of time, I had the opportunity to appear for the state, Milord, 14 years, 15 years ago. Milord, there were certain issues, Milord, which requires, because otherwise, Milord, the government, Milord, has to run its administration, but not at the cost of, Milord, the principles enshrined in the Constitution. Because it is every power is a trust, Milord. So, Milord, if it's a government of not main or by rules, only by rules, Milord, then, Milord, this manual, Milord, would only, Milord, define a contour, Milord, or trajectory.
Yes, the scope.
The scope, but it is not conclusive. That is why, Milord, the disciplinary
That's why I was grappling. I could not understand this. I have not come across such organization in my parent high court. There is a state vigilance, but that usually only leads to lodging of criminal cases in a trial, in a criminal trial. Otherwise, if the CCS is in place, it takes care of.
But central government, the parliament had, Milord, enacted law 2003.
No, but that is CVC is different. There also it is a criminal case. It's, does not overlap with the CCS.
I hope and trust that additional advocate general will come, Milord, with more information, more accurate.
Yes, we hope that he will be told or communicated.
No, that's a different matter.
We had asked him on the last day to show us about this vigilance.
I shall indicate it to him.
He is appearing. No.
No, Mr. Amol Shane Miller.
Oh, Mr. Amal Sen.
Item number 18.
Connected with 17, my lord, both.
Yes, same.
Mhm.
19.
I appear on behalf of the petitioner. But, Millard, before your lordship Millard peruses the order passed by the learned tribunal,
Yes.
I would be only indicating two things before my lords. Number one is that Millard, an advertisement was published by the Public Service Commission on 1st of March 2016 for recruitment to the post of junior engineer. That my lords will be pleased to find at page 65 to 69. Now, what I did,
Which department is this?
this is Public Service Commission.
No, engineers for which department? PWD, electric?
Various departments.
Oh, various departments.
Millard, I just, Millard, what I did for my lord's kind convenience, I have got the copy of the advertisement which is more legible. Now, significantly, Millard, your losses will be pleased to find that there was no announcement or indication in the advertisement about the number of vacancies to be filled up by the commission, subject to correction of my lords.
Yes, it says it will be announced later.
Yes. Now, Millard, I very respectfully submit that, Millard, the available vacancies and the tentative future vacancies that should be considered in connection with appointment of junior engineer, and your losses may kindly consider that, Millard, this particular, Millard, there were issuance of admit card for appearing in the written examination, and on being successful in the written examination, the petitioners were called for the personality test. This personality, the written examination was held on 12th of June 2016 at page 70. My lords will be pleased to find it. And the petitioners were called upon to appear in the personality test on 19th of September 2016. That my lords will be pleased to find at page 71. Now here, my lord, I should submit before my lords that if the particular vacancies are not being declared, or either on the date of advertisement or at a stage when the selection process starts, then, Millard, I am not in a position to know, firstly, whether I should compete. Secondly, what can be my relative position insofar as the selection process is concerned. Millard, supposing, Millard, there are 5, as a game, Millard, illustrative example I am giving, Millard, that there are 5 vacancies, and it is found, Millard, that 1,000 candidates or 500 candidates appear. There, Millard, I submit that an ordinary candidate should always assess, and there is also a chance that he may not even appear. But in a situation where, Millard, a particular vacancies were not declared. This, my lord, in my very respectful submission, I also found, my lord, a judgment of the Supreme Court where I found that this declaration of vacancies, this has to be done, my lord, at the time when the selection process starts. Now then, my lord, on 26/12/2016, my lord, I find that PSC declared vacancies for different departments.
26/12,
26/12,
16.
2016.
So nearly 3 months after the ET.
Yes. Now, my lord, your lordship may kindly consider that, my lord, this particular publication which was made on 26/12/2016, my lord, it appears, my lord, that PSC published a list of candidates on 20th of January 2017.
No, this declaration of results is by a notification. Declaration of vacancies is by notification.
No, my lord, I did not find that.
You said 26/12/16.
I say, my lord, kindly consider, my lord, for a second, my lord, for my satisfaction, my lord, just 1 second, my lord. Page 56. এখানে কোনো ভুল নেই। You know, kindly come to page 83. Sir, I think, my lord, subject to correction of my lord's, my lord.
26/12/16, yes.
This is not notification.
Perhaps it is on the website as it appears.
Yes.
So they must have said that all information will be published on the website at the outset. They must have indicated in the advertisement something like that.
You kindly see the vacancies as reported by various departments, Government of West Bengal are as follows. Recommendation will be made according to the merit position. Preference given by the candidates in a choice sheet at the time of interview and available vacancies. Now, my lord, this is there. Now, my lord, one
So
significant.
total is 1387.
1387
87.
vacancies were declared.
And you are in which category? How many of you?
My lord, we are
All unreserved.
Unreserved, yes. Now, your lordships may kindly consider. I think I was looking into the approach of Mr. Bose. Then I come to learn from his junior that he is not.
No, that is he's my senior, my lord. He's leading me. He's leading me, my lord. He's my senior. So I assistance.
Should we continue or not?
Now, my lord, your lordship may kindly consider that, my lord, so far as one of our contention was that, my lord, a department wherein certain vacancies occurred, that is in the Sundarban Affairs Department, that was also not taken into consideration. That, my lords, will be pleased to find at page 142. page 1. Page 141, kindly come, my lord. First of all, I appeal to my lords. Your lordships may kindly consider that in the serial number given in the left hand side under item number 9, Sundarban Affairs Department, there, my lord, there is a clear indication that vacancy is not reported.
Yes, it is the 9th,
Yes.
serial 9.
Number 9. Get on 4th of April 2012 at page 142, next page, my lord will be pleased to find that the member secretary and project director of the Sundarban Development Board, he writes a letter to the deputy secretary, Department of Sundarban Affairs. Estimate of vacancies in the post of junior engineer as on 31/12/2017
2017.
to be filled up by the result of junior engineers, civil, mechanical, electrical recruitment examination of 2017. Now here, my lord, they have indicated that I am furnishing herewith fresh proposed estimate vacancies of 25 number of vacant posts of junior engineer Sundarban Development Board, anticipated to be on 31/12/2017 in the prescribed pro forma, duly filled in, along with the statement showing date of occurrence of vacancy and copy of the recruitment rules, with a request to transmit the same to the Public Service Commission West Bengal for taking necessary action regarding sending of the list of selected candidates of junior engineer for appointment on urgent basis. One of our contention is, which I have taken, my lord, that the estimate of vacancy for the post of junior engineer Sundarban Development Board, that was not taken into consideration by the Public Service Commission while declaring vacancies of 1387. Now, one of the things, my lord, which I will be showing to my lords, that, my lord, normally my lords have laid down the law that normally the life of a panel is 1 year. Now, Now they have used, my lord, before I take to before I draw to the attention of the court about the points taken in the reply, I should indicate to my lords, my lord, that so far as these particular petitioners are concerned, my lord, the commission on 19th of September 2014, my lord, decided the cut-off marks for all personality tests conducted by the commission. Now these are, then they said that 40% for unreserved category, 38% for other backward classes, 35% for scheduled caste and 30% for scheduled tribe candidates. Now, in respect of taking decision for declaring cut-off marks, I cannot say before my lords that the authority do not have the power to declare cut-off marks, but equally I can say that this must be fortified by either any notification or any rule or any particular terms and condition in the advertisement. Lord, I did not find that, subject to correction of my lords. Now they declared that the cut-off marks is 40 for unreserved category.
That is not in the context of the present advertisement. That is a general declaration.
Right. এক সেকেন্ড, এক মিনিট করুন। 195 मैं बोल रही 40 and
They're OBC B. They're all OBC B. আমরা বললাম না, all are general. The statement is not correct. All are not general.
Millard,
Out of 50, 14 is OBC.
Millard, one thing, Millard, I find Millard in the petition that out of 50 candidates, 40 are unreserved
10 OBC B.
and 10 OBC. OBC B.
B.
B category. OBC B. And Millard, to that effect, it is called reported page 195.
195, 196.
Millard, to that effect, Millard will be pleased to find the report which was filed at page 195 to 197. Now, Millard, page 195 to 197 is a list of 53.
So your grievance is twofold. One is non-declaration or non-inclusion of the vacancies of that Sundarban board. The second is that prescribed cutoff was not there.
Prescribed cutoff was not there. And third is, the most important is that, Millard, in the particular advertisement, there was no specific declaration of the vacancies. Because why I say Just for a second, my lord, your lordships may kindly consider that under the heading vacancies, that was indicated that the number of
Announced later. It says it will be announced later.
to be announced later. Now, my lord, so if you proceed with the selection, if you proceed with the selection, and if a candidate cannot know what are the number of vacancies, then certainly there is, my lord, every chance of being prejudiced. Now, your lordships.
Now, yes.
My lord, just 1 second. On an earlier occasion, my lord, matter.
Please read paragraph 11 of the resolution. That is also.
My lord, on an earlier occasion, this particular matter came up before the.
It is a sheet anchor.
This matter came up for consideration before this honorable court, and my lord, your lordships may kindly come to page 182 to 184. 182 to 184. এটা আগে অর্ডার হয়েছে, সেটা সেট করে দেবেন। হ্যাঁ হ্যাঁ, তাই না?
So this writ petition was at your instance, or these were other writ petitions?
No, this particular, my lord, the order which my lord is perusing, my lord, this is at our instance.
You were all writ petitioners there.
Yes, yes. The matter was going for a long time. Therefore, my lord, they came up before this honorable court, and this order was passed. Now, I find, my lord, that in the operative portion of the order, which starts from page 183, I just draw to my lord's kind attention. On such consideration, we are of the view that the matter requires reconsideration by the tribunal. The West Bengal Public Service Commission is directed to produce all records relating to the said selection process and to offer an explanation for not recommending the names of the writ petitioners if required by way of an affidavit before the tribunal. The order impugned dated September 26, 2019, passed by the West Bengal Administrative Tribunal, is therefore set aside. We request the tribunal to dispose of the original application number 1088 of 2017 afresh as expeditiously as possible, preferably within a period of 6 months from the date of communication of the order. Any vacancy filled up during the pendency of the proceeding before the tribunal shall abide by the result of the writ application. Now, my lord, in my very respectful submission and subject to, my lord, the instructions which I have received, that, my lord, these directions which has been passed by this honorable court had not been complied with. Now, the other limb of my submission is that my lord, MA application was filed.
In the tribunal.
Miller, kindly see, this is a just 1 second, Miller. Any application, your lordships will be pleased to find. The 36th time. Miller, I have been instructed Miller to submit before my lord miscellaneous application which was filed before the learned tribunal. It starts from page 198.
229.
Now, your lordships may kindly my lord peruse. Kindly peruse my lord para 7 of the miscellaneous application. At page 229. My lord, may I just indicate to my lord that the said miscellaneous application was taken up for consideration on 10/12/2024. Has my lord got it, my lord? And as the original application was fixed for hearing on 16/12/2024, the learned tribunal was pleased to keep the miscellaneous application on the same date. On 16/12/2024, the learned tribunal was pleased to direct the applicants to supply the list of contesting candidates together with particulars to the respondent authority concerned and was pleased to fix the matter on 4/2/2025. Accordingly, such list was submitted by the authority concerned on 18/12/2024, and on the basis thereof, the respondent authority concerned submitted a report wherein they tried to portray that the reason for not recommending the names of contesting candidates is non-availability of vacancy in their respective categories. The applicants duly filled their exception to the said report. On 5th of February 2025, the said original application was taken up for consideration, and after hearing the parties, the learned tribunal was pleased to direct the respondent commission to produce relevant records before the learned tribunal. On 5th of March 2025, the respondent commission produced the relevant records, and the learned tribunal was pleased to grant liberty to the applicant to examine the records on the date and again on 13th of March 2025. In terms of the liberty, the learned advocate of the applicants examined the records as produced before the learned tribunal. From the records, it transpired that the respondent commission on 19/9/2014 decided the cut-off marks for personality tests conducted by the commission are 40% for unreserved category, 38% for the other backward classes category, 35% for the scheduled caste category, and 30% for the scheduled tribe category. It is pertinent to mention here that the marks fixed for personality test in the Junior Engineer Civil Mechanical Electrical Recruitment Examination 2016 was 100. Therefore, the cut-off marks for personality test are 40 for unreserved category, 38 for other backward class category, 35 for the scheduled caste category, and 30 for scheduled tribe category. In the said records, there is a list named as list of reserved category candidates whose marks in personality test are as per the relaxed standard get placed in the general standard merit list, which runs to 6 pages. However, 4th page and 6th page you are missing from the records. From the remaining 4 pages, it transpired that the said list that the following candidates in the general standard list, standard merit list, were appointed against unreserved category despite the fact that they did not achieve 40 marks in the interview or personality test, which is the cut-off marks for reserved category, and only became eligible for obtaining relaxation for the reserved status. The candidates are as follows. Well, I am skipping it over. From their marks, it transpires that none of them secured 40 marks in the personality test. Despite that, they have been considered and recommended against unreserved vacancies on the basis of their combined marks in the merit test and interview. Now, my lord, one of my very respectful submission before my lord, that I have made an application before the learned tribunal.
So the MA has been decided by which order?
This MA, my lord, I know specific, I do not find, subject to correction of my lords, that the order, my lord, which was passed, your lordships may kindly come to. This is one I am just showing to. Yes,
Order
that is.
number 649.
বলছি এইটা তো
No, order number 6. Dated 4th September 2025. Order number 6. Second certified copy in the certified copy.
my lord,
4th September 2025.
এটার ইমেটা কত বল আমাকে একটু, এটার ইমে নাম্বারটা
MA 36.
এটা দিস ইজ ইমে 36,
4th September 25. Order number 6.
ইমে 36,
Order number 6.
ইমে 36.
Order number 6.
Yes.
Order
My lord, this your lordships may kindly consider
Also
that.
on the same date it has been decided.
Yes. I'm grateful to my lords. My lord, I find, my lord, in my very respectful submission, subject to correction of my lords, the contentions raised has not been dealt with in its proper perspective. Now, the other thing, my lord,
So by the MA, what relief you sought from the tribe?
my lord, I had prayed for, just your lordships may kindly consider, page 235.
232, yes.
Yes. Your under the appropriate circumstances, your honor may graciously be pleased to pass an order to take note of the subsequent events and pass an appropriate order setting aside the general standard merit list of the junior engineers recruitment examination 2016 and treat the candidates as general standard merit list as reserve category and to be recommended and appointed against reserve vacancies and appoint applicants against such arising vacancies with effect from the date of the referred candidate joined to grant and grant all applicants the consequential benefits. I do not find, my lord, I leave it to the kind attention of the court. The other thing which I should draw to my lords, this is very.
So how many candidates you have identified? How many are they?
How many?
You have given the serial number of the candidates, but
Yes.
what is the total number?
It was not possible for us, sorry.
Yes.
No, because you have specific.
Complete search for the reasons. Whether these 2 pages were missing from the original report. PSC was writing the report.
Yes.
And we submitted the record below, and that record, 2 pages were missing.
So we have gone through it. You said we have read it. That 2 pages were missing, 4 to 6. Thereafter, you learned that these persons were treated as having secured the cutoff, though they did not secure, and they have been appointed against reserve vacancies. These persons, whom
There were more than this.
no, but you have confined to this number. You have not left it.
Option because I expected.
So therefore, what is this number? How many candidates? Now you are putting in question the recruitment of a particular number of candidates. How many?
Just a second.
You just make a calculation. We have just made the query. You can calculate. There is 10. There is 10 in a row. There is a number of rows. Immediately you can. Yes. 10 or 11 in a row. 10. Perhaps 2006. Sorry, 206. No, 2006, 206. 206. Because there are 10 in a row.
Yes.
No, there are 21 rows, so 210 plus 1, 2, 3, 4, 5, 6. 216.
না না জজ সাহেব নিজে ক্যালকুলেট করেছেন।
There is 10 in one row. How many rows are there from top to bottom? 20 rows or 21 rows. So 21, if you multiply by 10, it becomes. This. Oh, the last way there are 4-digit numbers. So there, yes, so 191. So 191 candidates have wrongly been appointed against reserved category post.
Now,
so even if they are removed, the relief will flow to how many of you? Only 10 are in the
sir,
reserved
may I
category.
say one thing? May I say one thing? What came to my mind, subject to what calls for my lord's kind consideration. Broadsheet showing marks of all candidates may be directed to be produced before this honorable court. The broadsheet. Because I had a privilege at one point of time to appear on behalf of certain authorities. This is an extrajudicial matter, kindly do not take me amiss. Now I found that there was illegality in framing the panel. Now I wanted from the authorities the documents, that kindly give me the documents. They said no. We are producing you the number of candidates in a phase-wise manner who have been given appointment. Well, at the outset, truly speaking, I could not understand that I should submit. I have no hesitation to say. But then I found that the original thing is not telling with the particular things, Millard, which have been handed over to me and directed to be produced in the court. Then the court, Millard, put certain questions. Then I told the authority that you have to satisfy the court. So therefore, what I very respectfully submit, Millard, that it is not possible that all candidates, Millard, who have filed a writ petition, they will be getting appointment. This cannot be an approach, Millard, which can, but equally, Millard, the error which was made or this attempt of the Public Service Commission, this should be, Millard, avoided and this should be, Millard, set at right.
See, the division bench which considered the matter earlier.
Yes.
Relegated this aspect to be considered by the tribunal. The tribunal got the records. Your stand with reference to the records is already on affidavit. So therefore, why the records have to be looked into again? You say specifically that page 4 and 6 are missing. Yes. And you say that these people have been allowed to cross the stage of, that is the stage of PT.
Personality test.
Personality test. Though they did not have 40% marks, they did not secure cutoff marks, and they have been allowed to, or they have been put in the selected candidates and offered appointment against reserved category posts. Now we'll see. This is your assessment from the records.
Yes,
It
but-
is on
but-
the affidavit.
Milord, your lordship may kindly consider that what I find.
Have they filed a reply to the MA?
Yes, that's a thing which I wanted to show, page 155. That is the thing I was, Milord, that is in my, Milord, that was what I wanted. Just kindly see, it starts from, first 3 paragraphs I skip over, nothing. Denied in, okay, page 155.
Thank you.
No, 155 is reply to the OA, not MA.
Yes, yes. And 299 is the particular reply to the MA.
This is more in the nature of, you may say, a supplementary or an amendment, because you
Yes,
say these
yes, yes,
additional
yes.
facts have to be considered. Sorry, 290?
298, 99. I stand now. 299.
And this prescription of qualifying marks is by a general decision of the commission. Wait, is that on record?
Milord, no. This is-
2014, you said there is some 2014 decision or notification. Commissions, so that is standard, it is applied across all selection. 40% cutoff in PT. No. Let us see. Now, your stand, you see in your reply to the MA what you have said. Just see your stand at page 301. That is why we are asking.
And also kindly consider page 301.
That's what we are saying,
Yes.
301.
Statements made in paragraph 7 to 9 and 11 of the said application are matters of record. I do not admit anything, 7 except what appears on the record. And I state that the personality test is completely a separate part of the examination to judge the suitability of the candidate. And thereafter, what they proceed. Millard, I think, Millard, it seems
It is not very clear, at
Yes.
least to me, it is not very clear.
What it seems to me that a statutory authority like the Public Service
Subject to
Commission-
what they will say, how they will explain these statements,
Yes.
but on a reading, there is some ambiguity. Therefore, we wanted to see where is that decision of qualifying marks at the PT. So if it is a general decision, it can be looked into. There is no dispute. Is it your stand that there is no qualifying marks for the PT? No, from your statement made in the MA, in the reply to MA, just read it. There is a question of instruction.
we can be directed to produce that particular Millard decision which they have taken.
Because at 302, you see the top paragraph at 302. What you have said at the top paragraph at page 302. Qualifying marks fixed for personality test level only indicate the qualifying marks to qualify for the personality test. Qualifying marks fixed for personality test does not determine the candidate's standard for different merit lists. So a general candidate category who got below 45% was declared unsuccessful. So they are denying that nobody below 40% was.
Just one.
Was inspected. Record was
The
inspected.
records were, I am told, Millard, that the records were inspected in terms of the.
My junior had inspected the record, sorry, Miller, and consecutive 2 or 3 days, Miller, in presence of the adversary member. Now, Miller, it transpired in paragraph 7, 229.
229.
229. Categorical statement is that the cutoff marks for PT
Was 40%, and your categorical statement is that those who have not secured the cutoff marks, they have been appointed.
Yes.
They are categorically saying this is not so.
Your Lordship know, Miller, that in terms of Miller, the provisions of the Code of Civil Procedure, it is an evasive reply. You have to say that it is not 40%, it should be 42% of the absence of statement, Miller. What would be the ramification? I put this question to myself. So, based on the Code of your Lordship's Miller, I have said this is a statement derived from the record in paragraph number 7 of the application are derived from another application. I believe page 34 of your Lordship's the academic page, we categorically stated that with the information.
So it is just an oath against oath. That's what we are saying in paragraph at page 302. They have, with reference to the record, stated so a general category candidate who got below 40% in the personality test was declared unsuccessful.
Right.
They are not agreeing to your statement.
Yes. If they are not agreeing, they should have come up with a specific statement that it should have been 42% or less than that. In absence of such statement, Milord, it is an evasive reply, and Milord, it attracts Milord doctrine of non-travel, subject to correction. I tell your lordships, Milord, that this is a long journey in this Kurial compact. It started its journey, Milord, Justice Shane's divisions bench order, your lordships were.
See, Justice Sen had narrowed down the scope of further scrutiny. He said just to say why they have not been recommended. Because at that stage, there was a case being made out that some vacancies have not been filled up. So he said why those vacancies are not being filled up. That is the, you see the order.
Yes, yes.
But thereafter, you see, you come to page 184.
Yes.
The commission is directed to produce all records relating to the process and to offer an explanation for not recommending the names of the writ petitioners. This is in the context of what has been recorded earlier, that although there was 13 some number of vacancies, only 1082 were recommended. So he said why the remaining, against the remaining vacancies, no vacancy was, no recommendation. That was the limited scope.
Paragraph 7,
Paragraph 7 only raises an oath against oath. Based on such statements,
they have eaten up. Because the seats which are now claiming, Milord, that is our legitimate claim, and they have eaten up their seats by reason of such illegal conversion.
see, after inspecting the records, you were in a position to state that serial number so and so has got 38% in personality test, serial number so and so has got so much. You don't say. You say though they have not secured the qualifying, they have been recommended. They say no, nobody who has not secured qualifying has not been recommended.
Ask them to produce the records, kindly. Because, Milord, if it is
subject to some doubt being created in the mind
of lordship, Milord, the trust the court had always laid down in terms of the Evidence Act with the institution. This kind of, Milord, conversion, absence of records, the court, Milord, I understand and trust and hope, is that from times immemorial, court has not taken any lenient view of this. The tribunal has, Milord, it is a case of, Milord, selective amnesia. Tribunal did not deal with this.
And what is your stand regarding page 4 and 6 being absent from the records?
302 to
Madam, your reply is there. What have you said in the reply? What instruction you will take now? First, go through your reply. These are issues specifically raised in their MA. Therefore, we are asking you.
Yes, yes, yes. 302 is the
302.
third paragraph. On the basis of the above, 302. On the basis of the above mentioned ground, some reserve category candidate got position in the general factor.
That happens all the time.
But in spite of getting less than 40 marks in PT.
Correct.
The other hand, that is the
So these are reserve category. They will go there having less than 40%. What is wrong with that?
4 2 candidates.
Sir, you please read that again. On the basis of above,
The above mentioned ground.
some reserve category candidates, not general. 40 is for general, not for reserve. So there will be less than 40.
The argument is this: in spite of getting less than 40 marks, there is an explanation.
Yes.
Yes. Now, Milord,
So that there's nothing wrong with that.
That is Milord, section 4, subsection 2 of the. This was, Milord, the enactment, Milord, the government of legislative department 76, West Bengal Scheduled Caste, Scheduled Tribes Reservation of Vacancies in the Service and Post Act 76 2. Section 4.
So what are you trying to say?
I am trying to say, Milord, this conversion apparent from the record. It gives no two ideas and opinions.
So what prevents a reserved category candidate from crossing over to a general category post?
The Supreme Court says that once you have taken the advantage of the initial stage to be appointed or to get the facilities, under this the member of any scheduled caste and scheduled tribe candidate qualifying on merit
Correct.
for appointment to any unreserved vacancy in a service or post in any establishment which filled up by direct appointment shall not be deducted from the quota reserved in such service or post.
Correct.
Such candidate.
Correct.
This has been done, contravention.
No, this doesn't say so. We don't know. We are unable to appreciate what.
Qualified on merit, but qualified on relaxation.
No. They have secured less than 40% does not mean they did not qualify. For them, qualifying was not 40%.
I said that.
For them, qualifying was 38%.
They should have, right, they should have been.
So there is nothing wrong with this statement.
They should have been accommodated as against the candidate quota reserved for them, not.
No. Where is the bar? Reserved category can always cross to the unreserved. The law is very well settled. Unreserved cannot cross over, but reserved cannot be reserved. There cannot be a reservation for unreserved.
Kindly ask them to produce the records and.
On the basis of this statement, we don't feel so. This statement does not lead to any such inference.
Paragraph 7 is very clear.
There is no reservation for unreserved. The law is very clear. There is no reservation for unreserved.
Subsection 2 has no meaning. Subject to.
That's not an issue arising here at all. On the basis of this pleading, that's not an issue arising. What they are saying is the unreserved, for the reserved, there is a below 40, they have qualified the personality test. Their aggregate marks have made them eligible to be appointed as unreserved. So they have been appointed as unreserved.
That logic is wrong.
We don't know. See, somebody who has secured, being an unreserved category candidate, 20 in the personality test, and a reserved category candidate, if he has secured 37, his aggregate may be above the. It's not an impossibility. So therefore, there is no doubt in the mind of the court for which we should ask them to come out with records on the basis of this. This is very much possible situation.
This possibility must be tested on the anvil of the.
Every matter, we cannot just call for the records like that.
Then I will show the latest judgment of this court. And it might lend assistance to your lordship. I will bring the judgment.
What, that there is a reservation for unreserved?
What is qualifying on merit and what is qualifying on relaxation?
What is?
Qualifying on merit, what does it mean? And why in this case I can take recourse to the judge?
Which judgment you will rely?
But it is from the DOBD department of the last. I shown.
No, you are just give us the citation. We will allow you to. We are not saying that you cannot. You will place it. But which judgment?
Yes,
Give it.
My submission is, Lord, I make very little limited submission, which I had indicated to my lords. I got only one judgment of the Supreme Court, where your lordships will be pleased to find that kindly consider paragraph 5 and 6 of the judgment. What I told your lordships, that an opportunity should be, you will kindly see this paragraph 5 is the position of law of section 29. The relevant is paragraph 6. A reading of section 29 would indicate that all appointments to the permanent post of teachers in the university shall be made by the Executive Council on the recommendation of the selection committee in accordance with the provisions of the statute. Such posts shall be duly advertised and the candidate concerned would have an opportunity of being interviewed by the selection committee except in cases where such committee decides to consider the case of a candidate otherwise than by an interview. The object thereby is that all permanent vacancies should be filled up by advertisement, giving opportunity to all eligible persons to claim for selection by the selection committee in the regular process.
So your stress is on all permanent vacancies.
This is the only thing I cannot, because when I have to make a submission, I have to be fortified by something which can come to the mind of the court that this can be.
The learned senior advocate.
that the order has been uploaded, the circular. Now satisfied to tell you what I keep one candidate.
You have given an undertaking. You have.
Find the certificate at the time.
First, just a minute. Where is that? There was one petitioner was appearing in person. He was here in the first half. He is there. All right. Let him wait. After these two matters, call his.
Item number 2.
My Lord, I have filed one CAN application. Really are praying for the TET 2022 matter. Really are praying for providing a copy of the expert report. Ready, my Lord, before the single bench.
These matters are fixed on a particular day. Because we have just started the system, there is some they are not understanding. Friday, when it is adjourned, it will come on Friday. So it will appear on Friday. Okay.
Supplementary list item number 1.
My Lord, in this matter, my Lord, I beg to appear on behalf of the my Lord, appellant petitioner, my Lord. My Lord, today, my Lord, the interim order was, my Lord, about to expire, my Lord. So that's why, my Lord, I have mentioned this matter, my Lord, for the purpose of extension of the interim order, my Lord.
What is the interim order is dated?
My Lord, interim order is, my Lord, dated. Initially, my Lord, it was given on 21st of August 2025, my Lord. Thereafter, my Lord, it was, my Lord, time to time extended, my Lord. All wide, my Lord, order dated 29th October 2025, my Lord.
So till 8th, we are extending it till 8th.
My Lord, my Lord. My Lord, I would seek
Yes,
you
yes.
kind leave to, my Lord, file a supplementary affidavit, my Lord, which was, my Lord, directed to you.
All that you do before when the bench is there. Yes.
Lordship, paragraph 8 of the ST application, Your Lordship. Allow me only 2 minutes time to submit before Your Lordship.
We are not hearing the matter. We are just extending the interim order, nothing else. Yes, heard the learned counsel for the writ petitioner.
আসবে না তো বিপিন চ
Deeply obliged.
Item number 28.
Monica Roy is appearing for the appellant lordship. I am seeking for short.
You are for the appellant. You are for the respondent. Then why you are mentioning, sir?
Item is listed in.
So therefore, when it is not your case, why you are mentioning it is their case? Whether they want to do today or they don't, how can you dictate whether they want to do their case today or not? We thought it was your case. You have to wait. What can be done? Can't force them to argue before their matter is taken up. Any interim order is operating against you.
Sir, appointment
Is
order
there any interim order against you? Then why you wait? Let's see if they, when they come, call the next case. We thought you have filed the writ petition.
Item number 20.
None. I'm led by Mr. Shopun Manager.
Supplementary to Jama.
Course. I'm filing my at first the affidavit of service minor, date minor in the last petition you are given me liberty to file supplementary affidavit. Several supplementary affidavits.
Yes, supplementary taken on record.
May I please, my
Yes, what is wrong?
In this matter, my lord, the advertisement was published on 20/12/2019. Then, my lord, interview was held on 29/12/2020. Then what has happened, my lord? In the advertisement, my lord, if your lordship kindly takes up the advertisement, it is at page. It starts from page 17. If your lordship kindly come to page 19, the required qualification. Page 19. My lord, the last paragraph, serial number 1, required qualification. Page 19, last paragraph.
Nineteen of the writ petition.
Yes.
Yes.
My lord, page 19, my lord, last column, my lord, qualification. Qualification is, my lord, Bachelor of Homeopathic Medicine and Surgery, BHMS, for recognized university institute, my lord. Now, the respondent number 1 is not possessing any BHMS degree, my lord. He is possessing graded BHMS.
And what is graded BHMS, my lord? There is a difference between BHMS and graded BHMS. Graded BHMS means at first he has completed one diploma course, that is DHMS, for 2 years. Then he applied for the BHMS course, and that is for 2 years. Total 4 years. But in BHMS course, my lord, it is a 4 years, continuous 4 years course, my lord. There were some students or some candidates who were possessing graded BHMS. Then the authority thought that yes, in the advertisement it is stated that only BHMS candidate will be considered, but later on the authority thought that graded BHMS candidates will also be given some opportunities, my lord. For that's why, my lord, we have issued one circular, board's resolution 31/8/2021, my lord. After that, my lord, on 31st/12/2021, a panel of 243 candidates were.
Where is that?
Your lordship, the board resolution is in my supplementary affidavit, my lord. That was the direction of your lordship to bring that record on record, my lord. Supplementary affidavit. It starts from, my lord, page. My lord, page 38. If you lordship kindly come to page 41. Page 41, top, my lord. West Bengal Health Recruitment Board has also decided regarding the recruitment to the post of homeopathic medical officer by advertisement such and such dated 2012-2029. Well, that is the advertisement, my lord, which was issued on that date. Then if you lordship kindly come to the item number 2. If any candidate has completed graded BHMS after completion of diploma DHMS, marks obtained by such candidate in both diploma and graded BHMS to be considered for evaluation of marks obtained in the equivalent BHMS, my lord. And what has happened, my lord, we have considered them. Now the candidate who is respondent number 1 doesn't come within the zone of consideration, my lord. At the first of all, it is a qualification is BHMS. We have also considered them. Then, my lord, kindly come to the impugned order, my lord.
Rejection is by which order? The authorities have passed any order.
Yes, sir.
Where is that?
I'm showing you. It is at page and come. My lord, 23/11/2023, page 31, my lord. Page 31.
No, this is order of the tribunal.
This is the order of the department, my lord.
No, 31 of writ petition.
No, my lord. What has happened, my lord? When he was
31 of writ petition.
The writ petition, my lord. Candidature was not considered. He made one representation, my lord. After that representation was not considered, he filed one original application before the tribunal. Tribunal directed the authority to consider his representation by giving an opportunity of hearing. And then if he is otherwise eligible, he will be considered. And this is the order which the authority has passed, and challenging that order, he came to the tribunal for the second time, which is the impugned order before your lordship, my lord. My lord, if your lordship kindly come to page 33 is the relevant one, my lord, of that order. The entire dispute comes from, and my lord, wrong information given in pursuant to an application under Right to Information Act, my lord. He is also admitting that calculation error, and we are also admitting that there is a calculation error, my lord. The relevant portion is page 33, bottom portion, my lord. May I read, my lord?
Please, please. Yes.
My lord, page 33, my lord.
Yes, we have seen.
We have not. My lord, what we are on, my lord, there is a calculation error, my
What the tribunal has directed.
lord. Tribunal has also found that there is a calculation error, and he is also admitting that there is a calculation error, and we are also admitting there is a calculation error. But we both submissions are something different. We are saying in the minor right to information's minor reply, the total marks was considered as 75.5. Now he is saying, according to the body of the reply, total marks will come as 80.5. And we are saying, see, the total marks was given 75.5, and we have given the calculations.
What is the date of his participating in the interview?
My lord, participating in the interview, my lord, he participated on, my lord, I'm coming now.
29th of December
29th of December 2020.
internal page 3, my lord.
Calculation is very specific, my lord. As because he is possessing the graded BHS, my lord.
What is that?
2 years diploma and 2 years degree. Then the total marks what is obtained in diploma, that is to be added, divided by the all the subjects. Total marks in the all the subjects, that will be divided by that into 100. As because we have to take out the percentile of that. He obtained 1347 in the DHMS and then 1202 in the BHMS. And in the total marks was 2100 plus 2000, then it into 100. So it comes about 2549 divided by 4100 into 100 equal to 62.17. It's not that, my lord, that 5 marks is added with the academic score. He obtained only 62.17 marks. Then, my lord, in the according to advertisement, my lord, if it comes under the zone of 56%, the zone of 56% to 65.99%, then he will be awarded as 65 marks. Now he is coming and his percentage is 62.17. For that, so we have awarded him 65 marks, adding five marks. That is, my lord, he obtained in experience category. Then 65 plus 5 equal to 70. He had got one supplementary in one subject that will be deducted according to the advertisement, my lord. Then it comes to 69.5. Now, my lord, furthermore, 6 marks for interview. If we added 6 marks along with 69.5, it comes to 75.5, my lord. And in the last part, if your lordship of that order, it is pertinent to mention here that the reply by the SPIO WBHRB under RTI Act 2005 by memo number such and such dated 8/3/2022 appears to be wrong, as the score sheet downloaded by the applicant from the official website of the WBHR also reveals that he obtained total 75.5 marks. In no way the claim of the applicant can be accepted, as the mathematical calculation itself shows that he has obtained only 75.5 marks and not 80.5 marks, my lord. That is a mathematical error, and we admit, my lord.
Tribunal has not gone on that. Why are you saying that?
My lord,
Tribunal has not gone on that.
My lord, at the first portion, my lord, tribunal's order, the page 1, my lord, last paragraph, my lord. After close examination of the reason order, it is understood that no separate marks for experience was allotted to the applicant on the ground that the academic score is inclusive of experience. This is not true, my lord. This is not true. Why? If your lordship kindly come to the order, the next page 34, my lord, that is the order passed by the authority, my lord. What he scored, my lord? It is stated that no separate marks of experience was allotted. Yes, my lord, separate.
First page you are reading from the first page, that is finding of the tribunal.
My lord, first page means of the impugned order, my lord.
Just now you have very emphatically stated no separate marks for experience was allotted. On that ground, academic score is inclusive of experience. That is finding of the tribunal.
After close examination, tribunal is saying that, my lord.
See, after that also the submission is continued.
Yes.
These are submissions. They are saying that after close scrutiny of the reasoned order, this is what it appears. Finding of the tribunal is after that. Tribunal is also not convinced. It starts from the second page.
Convinced with the argument of the respondent authorities that academic score includes the experience.
Correct. From there,
they are not convinced. But my lord, I'm pressing before your lordship, my lord. Yes, my lord, academic score is not, my lord, 69.5. Academic score is 62.17. We have given 5 marks extra for his experience. It's not that it is included. It is stated in the reason order also, my lord. We have given experience marks.
Yes, you have.
It's not true.
Where is the RTI reply?
RTI reply is palpably wrong, my lord. That I have admitted.
Where is the RTI reply?
RTI reply, my lord. I'm coming to that. My lord, it is at page 28, my lord, of the writ petition, my lord. It's not one, my lord. I'm coming. No, it is at page, my lord, 27. 27, my lord. Your lordship will find the total marks, the RTI is saying that it is 75.5. Interview 6 marks, experience 5 marks. Academic score, they are saying 69.5. This is the wrong what they have did, my lord. It is not 69.5. It is 62.5. And it is very specific, my lord. We have given the entire calculations in the order, my lord. We have considered, if we go by the advertisement, his candidature will not be considered. Department was very lenient to consider those candidates who are possessing graded BHMS. But percentile has to be calculated, my lord. As because for the BHMS candidate, percentile was considered, was calculated. For him also percentile will be calculated. After calculation of percentile, he is not coming under the zone of consideration. And they are the degree holder, my lord. BHMS, and he is the graded BHMS, means 2 years diploma and then
How many times you will make the same submission?
No, my
The third time you are saying that. We have understood what you are repeating the same thing. According to you, originally they were not entitled. After the board decided they were entitled, the board devised a procedure that the 2 degrees, 2 years from this and 2 years for that, are to be calculated by an aggregation system. As per that, he is not eligible. This is what you are saying.
This is what I'm grateful.
And he is relying on a wrong information supplied by the RTI.
Yes.
This is
He's
your
not
case.
saying it's a wrong one. I'm also saying it's a wrong calculation.
Whether he is saying that, he will say. Whether he is saying or not, that he will say.
I'm grateful.
Yes. In the marks calculation, page 31. 31 of the page. And in the list result which has been published, what is the mark shown by him against his name? The result must have been published before he approached the RTI authority.
My lord, he is not coming under the zone of consideration, but he was getting
Marks were not displayed.
No, my
Marks were not
lord. Only 75.5% marks he has got in, my lord. That was not displayed, my lord, as because he is not coming.
Before coming for RTI information, a result was published. In that result, his name is not appearing.
Not appearing.
In that result, was the marks obtained by the candidates displayed or not displayed?
No.
And this method of calculation of the marks, it is based on which formula? From where you have derived this formula?
Only percentage.
No, it is based on.
It is uniform standard, my lord. It is for all the candidates. Even the BHMS candidates which they appear.
Where is that calculation you had shown?
Calculation, my lord, calculation part.
Page 31.
And also in the supplementary affidavit at paragraph 5 and 6 I have submitted, my lord.
No, where is that reply? Reasoned order.
Page 34.
Reasoned order.
The writ petition.
Page 34, my lord. 1347 is the marks which he obtained out of 2100 marks in the first.
Yes.
My lord.
In DHMS, he has got 1347. In DHMS, he has got the total marks percentage they have taken out. After it comes to 65, as what they have. Yes, because in this range it has to be placed this. There are 5 marks for experience, but from that 0.5 is deducted because there is one here supplementary. Yes, so it has comes to 69.5. 6%. Yes.
At very beginning, my lord, it is my duty to point out the supplementary affidavit which has been filed. My lord, the reasoned order or the order, it relies on the 163rd meeting, but the minutes which have been annexed is 162nd. And my learned friend can clarify on this, that whether it is the 162nd or the 163rd.
162nd, my lord.
But in the order copy, their submissions, everywhere it is the 163rd board meeting. Nevertheless, my lord, it is my duty to bring it to your lordship's kind notice, so I have brought it. Now, lordships,
This is 162nd. Anyway, that does not bring this. They have annexed this document, so they are relying on this document.
it is my duty to place it, to bring it to your lordship's notice, so I have brought
Yes.
it. Now, lordship, it is not in dispute that the advertisement had come up in the year 2019. I gave the interview in the year 2020, and this resolution which they are relying upon is in the year 2021.
21. Yes.
Therefore, my lord, clearly in the advertisement itself, there was no provision for such distribution of marks in that manner, that I will take some from here and some from there. Now, that was the main contention before the learned tribunal, wherein we had clearly stated that once the advertisement is published, the recruitment process starts.
What is the date of after this 162nd meeting?
My lord,
Result has been published on which date?
First of December 2021.
So till then, did you lodge any complaint or grievance that why you are applying such a decision?
But since the method had come up, since the panel had come up, and when I did not find my name, then only
When they have taken a decision on 10/8/21 to allow DHMS also into the recruitment process
but it was not known
or
to us.
integrated DHMS, this was not made public.
No, to the best of the knowledge which I have gathered information from the petitioner.
Let us see from your way where you have said that no intimation was given regarding this decision.
But it was never ever made public.
So let us see where you have said in the OA.
Your Lordship, kindly give me one moment, my lord.
Yes, yes, you find it.
এটা পাবলিশ হয়েছিল ওয়েবসাইট ইউজ করতে পাবলিশ হয়েছিল কোথায় হয়েছিল
Yes.
perhaps not so specifically stated, but it has been also stated that the resolution dated 31st of August 2021 has not seen the day's light when the West Bengal Health Deputy.
Correct, that is correct. It had not seen the date of light when when advertisement was published. There is nothing.
But specifically, well, I can make out from here. Well, it has not been specifically stated.
That's not your case.
That's not been stated there.
That's not your case. What you are submitting is not your case before the tribunal. Before the tribunal, you are just saying that why this subsequent resolution is being relied upon. You are not saying that we did not know about the resolution. You are making an issue by why they are relying on this resolution. You are not saying that you are not knowing about the resolution. You are saying it never came to light at the time of advertisement.
Yes.
That is all.
Therefore, subsequently, you cannot change or mold the.
So therefore, we asked you when the resolution was taken, why you did not raise an objection.
It was published in the website portal, my lord.
Must have been. Otherwise, he would have said that it was not published. He has not. That's why we asked him, where is that?
But that much, my lord, I cannot say, my lord, and I cannot go beyond what has been.
So
taken.
therefore,
No, my lord.
if that had not been issued, you would have been rejected outright for not having the BHMS. So you have actually benefited from that decision by coming into the zone of consideration.
No.
And you have taken benefit of that resolution. Otherwise, you would not have even been in a position to apply under RTI because you would have been disqualified for not having a BHS.
What may I say, my lord? This resolution has also clearly stated about two things, my lord. It is relying and it is stating that those who have not submitted my candidature would be outright rejected. If that be so, then it could have been very well straight away rejected. There would have been no difficulty at all. Then I could have challenged and I could have come up with a new case. But once having something which was not in the advertisement, my lord, can they apply something?
That's all.
Which is not in the advertisement, which does not empower them to formulate such principles to add 2 marks, taking clubbing for both the patterns. Therefore, my lord, once is subsequent one, Lord, how can that change? How can that be applied?
Yes, what other point? That
Well,
we have understood.
Well, that is, my lord, my primary point.
Yes.
And my lord, the tribunal has rightly also stated that what they are saying, that the marks which have been given to me in the academic one is inclusive of the experience. My lord, I object to such because the advertisement, if your lordships may kindly takes up at page 17.
You are objecting to what?
Objecting to such, my lord, where they have stated that the academic score which has been given to me is inclusive of the experience.
Where?
Yes, but that they have stated. That has been the submission of their learned counsel.
Where? Sure.
Lordships may kindly takes up the internal page 1 after close examination of the order. Lordships.
No. Where have they taken this ground? You cannot say it from the order.
No.
You will have to show us from the records.
Yes, that is what Mrs. Agarwal, learned counsel appears.
That will not help you, sir. You may read the entire order 10 times. The question will remain the same where they have said that it includes the experience. Where they have said you are taking objection to this. You have not challenged the tribunal's order.
I have not said.
So show us from the record.
At the page 3 of their supplementary affidavit.
Of their supplement.
Yes, sir. Page 3, my lord.
Yes.
Full lines from the top. Therefore, his academic score which is inclusive of marks plus.
Sir, we are asking you to show us what was wrong by which you approached the tribunal, not what they have said in these proceedings. You have gone to the tribunal challenging the reasoned order.
Yes, my lord. The reasoned order states.
Yes, now
that-
come to the reasoned order. What they have said in the affidavit hardly matters. We are here to see whether the tribunal has arrived at a conclusion which is sustainable or not.
I've understood.
Now we will tell you, come to page 34.
Yes.
Fifth paragraph from the top. Moreover,
Moreover, it appears of the candidate files the applicant that he obtained 5 marks in experience category in accordance with distribution of marks pattern as mentioned in the advertisement as stated above. Therefore, his academic score, which is inclusive of marks plus experience.
yes,
Now, my lord, I say this, the marks plus experience, this cannot be because the advertisement itself separately provides that I am entitled to get experience. Lordship kindly sees page 20 of the writ petition. There is a separate column for experience.
Page
20, my lord. That is the column number 3. Other experience in homeopathy from any government affiliated organization. This is where, my lord, I have not been. They are stating that the academic marks which you have got is inclusive. I say this, that 69.5 is the correct marks. I am entitled to 5 marks there and 6 marks as given in the RTI. Experience marks has not been given to me, which they are saying that it is within the academic marks. And I say, my lord, that the academics marks which they have come to by applying, my lord, 2 separate procedure, that is not permissible because it has changed the rules after the advertisement was published and after the recruitment process was undergone. Now, something which is not in the advertisement, it cannot be incorporated subsequently. Therefore, my lord, the 163rd, that memorandum by which they have applied the distribution of marks, whereas that is not correct.
no, it does not contain any distribution of marks.
No, my lord. What they have done, the
It does not contain any distribution of
I'm
marks.
sorry, my lord, it's not the distribution of marks, it's the calculation of marks.
You are stuck on that point. You have already made that point. We asked you to go to the next point. You are saying 162 cannot be applied. That we have already understood. Now the next point is whether this 5 marks is to be included or not included.
Yes, my lord, which they are saying that is within my academic one, and I say that it is not there. I am entitled to a separate experience where a separate column has already been provided in the advertisement itself. Therefore, I am entitled there too. The distribution of marks, is a wrong term. It should be the calculation of marks.
Yes, but that marks has been awarded to you separately. 6 marks.
Yes, my lord, what would happen? I tell your lordships that here.
No, just a minute. You are claiming how much marks for experience?
5 marks for experience.
No, you are claiming 6 marks for experience.
No, the interview I have got 6. 5 marks for experience and 69.5 for academic.
6 is for interview.
Interview, my
5 marks. So you are saying that the 5 marks for experience should have been added to 65.
No, should be added to my total score of 75.5.
Is there any written test also?
No, my lord, only the
No written test.
documentation and the interview part. Written হয় না?
One is the sum of documents, which includes, which comes through submitted in support of his degree, documents submitted in support of his experience. That is what the same word. Yes, one. For which he has got. Yes.
My lord, I am saying this, my lord, this 62.17, which we have come, it is the result of a resolution taken afterwards, which
It is not. There is nothing in that resolution.
no,
You cannot just make a submission. It has to be founded on something in the pleading.
that is the resolution of the 162nd board meeting.
162nd says nothing about marks distribution.
So
It is only about DHMS, PHMS. It is not saying anything about that 5 marks. There is not a whisper about that 5 marks. It does not touch experience.
no, Dr. Kailis is one.
Please read where it says experience.
Dr. Kailis is only one moment, my lord. Here the academic score is coming down to 62.17 by applying that formula. That my
Please
lord,
show 162 where it says experience.
yeah.
You may. We are asking you. Show where it says experience.
This is perhaps not there, but my
Not perhaps.
it's not,
It is not there. Don't say not perhaps.
it's not there, my lord. But
It has nothing to do with experience.
my lord, what I am trying to
What you are submitting is your first submission. You have already made that submission.
that by application of this, my
Correct. That you have
academic score
already.
is coming down.
No. By application of this, you are saying that this does not apply because both the degrees are being clubbed together.
Yes, my lord, and that is number one. And even if assuming there the it
No assumption and presumption. Something which is there or not there. No assumption or presumption.
then my lord, it comes down to 62.17.
Huh?
Comes down to 62.17.
We don't know how you are calculating.
No, that they have calculated, that they have stated.
Yes.
There is in order. Now, my lord, I say this 62.17.
What is your score in BHMS? Graded BHMS?
1347.
How it can be?
It has been stated, my
It has to be both taken together. There cannot be an aggregate for this graded BHMS. It always has to include both together. Otherwise, it cannot be calculated. If you had done BHMS, you would be having 4 years in BHMS, then the calculation would be possible. Otherwise, your calculation was not possible. 162nd board, they took a decision that yes, we will allow them also. Both will be clubbed for the purpose of calculation. And they have not changed the method of calculation. They have only, instead of first 2 years of BHMS, they have allowed DHMS. That is all. They have not changed anything. It's not your case that the others are being evaluated on a different parameter and you are being evaluated. If at all someone would have a grievance, it would be the BHMS holders. They could have challenged this board resolution that why you are allowing them when they are not BHMS. They did not challenge. You benefited from that. Otherwise, you would have been excluded altogether. That is a facts as it is.
That might be, my lord, but well, the point is this, my lord, they could not have applied this.
Correct. This is the seventh, eighth time you are saying that. You have argued 2 points.
I'm sorry.
Yes,
Kindly.
that's all.
Yes, and my lord, I am relying on Tej Prakash Pathak's. My lord.
Yes, why not?
Your lordship knows this. My lord, I need not once again. It would
Considering Manjushri and all those judgments.
it an event.
You give him you make your submission on this judgment tomorrow. Take down. For further consideration, matter is adjourned, not today.
I will also produce one at Tej Prakash. It is with me, my lord.
You may.
But if my lord allows, then I can place. My lord.
What judgment? You have already argued. You just deal with his judgment.
Given he is already armed with it. My lord,
If your lordship allows me to proceed, my lord, I can proceed.
No, on that judgment, you make your submission tomorrow. Yes. Yes, call the next.
21.
I'm grateful, my lord. Well, I'm sorry, my lord, if I have repeated some points.
No question of sorry.
যিনি আগে
None appears on behalf.
December. First December. 22.
I beg to appear on behalf of the petition, appellant. Read petitioner appellant. The challenge.
He is appearing with you.
Pardon?
He is appearing with you or he is appearing for the respondent?
Perhaps for the respondent.
For the respondent.
But the charge sheet included two persons, two delinquent employees. One was dismissed from service by a common charge sheet, and another was reduced in rank. It is under the Border Security Force Act. My lord, my first argument before your lordship will be the disproportionate punishment has been meted out to the writ petitioner who happened to be one of the delinquent employee charged in a common charge sheet, common disciplinary proceedings, common set of evidences, but the discrimination has been awarded. One has been reduced to rank, and the appellant before your lordship who has been dismissed from service.
Yes. So which law says that all the accused in a departmental proceeding have to be given the same punishment?
But that is my submission that disproportionate punishment has been awarded.
No,
and it has
you said that while one has been awarded lesser, I have been awarded more.
I have been awarded more.
So where is the law which says that all the accused have to be awarded the same punishment?
May I just refer to the two decisions of the Honorable Apex Court?
Yes.
In that event of 2008, Volume 2 SCC.
Yes.
Prior to that, may I bring to your lordship to the charge sheet once?
You have accepted your guilt. There is a confession given by you, a statement made by you.
To that extent, I will be submitting, my lord, that my confession has been obtained under coercion, undue influence.
All right, that we will see. Primary objection is that one has been awarded lesser punishment, I have been awarded more.
Yes.
So which law requires the disciplinary authority to give the same punishment to all delinquents, irrespective of their role in the offense, irrespective of their background, irrespective of their antecedents? There is no way that they are to be given different punishment. In fact, the law is contrary, as far as we know.
If my lord may kindly considers, my lord, 2008, Volume 2 SCC, page 74, paragraph 5 and 6. Paragraph 15. 2008. Yes, paragraph 15. It is true that delinquent officers similarly situated should be dealt with similarly. And if there is a charge against the employee, employees are identical, it is desirable that they be dealt with similarity. And this has been also been held subsequently.
So
by
that is the law. That is the law declared by this judgment.
That is the ratio of the law laid down.
What are you submitting, sir? Please read the judgment in its entirety.
Yes, ma'am. May I
Please read.
May I place it?
Yes, just read the next paragraph after 15.
Quantum of punishment imposed on a delinquent employee by the appointing authority, however, depends upon several factors.
Several factors. Precisely what we had said just now. Yes.
Conduct of the delinquent employee or officer, as also the nature of the charges play a vital role in this behalf.
Correct. So there is no question of same punishment being awarded to any other judgment.
But apart from this, my lord,
Yes.
if I take your lordship to the charge sheet and the set of evidences that has been
We
laid
are not sitting in appeal.
out of two charges,
We are not sitting in appeal. You are in a judicial review.
judicial.
So
But-
we are not sitting in appeal.
My lord will kindly consider out of the two charges, so far as the first charge is concerned, both the delinquent employees have been said not guilty.
That we have seen. Both have been held guilty of second charge.
And second charge is suffers from duplicity of the first charge.
Maybe.
If I have been acquitted in the first charge, then the second charge,
We are not in appeal.
which is not an independent charge in
Sir,
itself.
you are not in appeal. You are in a judicial review.
But that point that has been
The punishment has been inflicted under which rule?
under the Border Security Force Act.
Where is the provision? Let us see. There is an appeal provision.
Yes, appeal I have consumed. I
And
prefer a statutory appeal.
that has
Statutory appeal affirm the order of the disciplinary authority.
and divisional authority also.
Disciplinary authority convicted me, awarded a discrimination award. One was reduced in rank, and I was being removed from service. A statutory appeal was taken.
Not discriminatory, a different.
A different
Yes.
statutory appeal was preferred.
Yes.
Statutory authority affirmed the order of the disciplinary authority. Again, against which I preferred a writ petition. The writ court.
You want to be treated at par with someone who has not done any misconduct prior to the present, whereas you have been convicted 4 times in the last 12 months.
Yes, but that being my exclusive submission.
So you want parity with that person.
Taken into consideration.
And on such facts, you are alleging discrimination.
But not only on that fact, my lord.
All right.
If my lord may kindly takes into consideration under what circumstances my evidence has been taken and that has been adduced against me.
Yes.
It is under coercion, undue influence and threat, which is against the provisions of section 14 to 18 of the Contract Act.
No, Contract Act. Let us see the BSF Act under which the procedure has been conducted. Where's the
My lord may
question?
kindly takes into
Evidence Act will apply to a departmental proceeding.
No, Contract Act, I said. That the provisions of the fraud, coercion, undue influence, that is section 14 to 18 of the Contract Act, it says that if the evidence has been taken on the basis of some coercion, undue influence and threat, that would not be taken into consideration. I will place the evidence of
Come to the BSF Act and rules. What is the procedure
Yes,
prescribed?
my lord may kindly considers Rule 101 and 152 of the BSF rules.
BSF. Get it. Tomorrow we'll take. See, we have to rise. We don't have the act also. We'll consider it tomorrow. Get the act. You will have to be borrowed.